My name is Chris. I was in the um, murder trial of Christopher Taylor, and what you know, I wasn't there the entire trial. Let me start off by saying that I was not there the entire trial, which I wish I was. So the first trial was a mistrial because they couldn't seat a jury. That's as far as I understand. I could be wrong, but I think that's what it was. More or less, they couldn't seat a jury, and they decided to, the defense motion for a mistrial. It was granted. They also motioned for a change of venue. That was denied. There was a lot of affidavits that came forward from prominent lawyers and former district attorneys saying, yeah, this may not be the best spot to try this trial because it may be hard to have a impartial jury because there's just been so much media coverage of this guy. Yeah, when you seat a jury, you want an impartial jury that the golden standard is they know nothing about the case and they can be impartial and bring their own life experience and only listen to the evidence presented in court according to the rules of evidence and according to the rule of law as given to them by the court. I guess that would be the golden standard. If they don't, if they have seen coverage, can they set that aside and be fair and impartial and only decide on evidence presented in court? Because evidence presented in court is supposed to follow the rules of evidence. And it could work for you or against you depending on the circumstances. If you get pulled over by a cop and you have a bunch of drugs on you, but the stop was not legal, it's possible. It doesn't always happen, but it's possible that all the evidence presented after that, the fruits of the poisonous tree, is thrown out, and they really have nothing to go after you for. So in that circumstance, it works quite well if when it works, right? But also, it could also work against you insofar as there can be evidence brought in that is very prejudicial. What you said on Facebook years back and stuff like that, when you're being judged on whatever violent charge or whatever, you want. So yeah, it can be used for you and against you. And so, um, I'm glad that they seated a jury quite quickly from what it sounded like on their second trial. That's good. I think in these trials, it's important to understand that these are very complicated events. They're also very simple, right? So they're both very complicated and very simple. Is all right. The simple portion of it is the person guilty or not guilty, right? I guess that could be the simplest part of it. The complicated portion of it is what is the law in which they committed the alleged offense? Do they have an excuse to being prosecuted under that law? Are there exceptions? What are the surrounding circumstances? Are there mitigating factors? Um, uh, and the thing, the information you get on what to judge a person by you should question it quite rigorously because, we live in the age where everyone has cameras. But I think it's important to point out that sometimes cameras only show one view of an incident, and it may not be the whole story. There there are cinematographers in film for a reason because the vantage point matters. So, all that being said, I was in the closing arguments of the second trial. And it was very interesting to see um, how all that played out. Um, when I walked in, Doug O'Connell, the attorney, one of the two attorneys for Christopher Taylor, had headphones in. He was just kind of like, I think he was just getting in the zone. This is where it all comes together. Closing arguments. This is what often is the last thing that a jury hears from both sides. Ken was on his laptop. I don't know what he was doing on his laptop, but he was on his laptop, as were a lot of attorneys in the courtroom right at that moment. Um, so they started out with the jury charge, and the judge laid out different aspects of that jury charge. Aspect 1, the offense; 2, the definitions; 3, defenses; 4, beyond a reasonable doubt; 5, self-defense; 6, defense of third person; 7, presumption of innocence; 8, burden of proof; 9, right to remain silent; 10, safety for the jury members. And apparently the jury members were allowed to visit the scene of the incident that took place. So that's cool. I'm glad that they got to see it. It definitely helps when you see an incident and allows you to at least consider that, right? I have to give the judge props for that one. I'm sure that was a logistical nightmare. 11, general provisions. Stay on topic. Do not consider punishment. Do not listen to the media. Lawyer arguments is not evidence. Evidence is what is admitted. Inferences. You're only allowed to make inferences from the evidence. Transcriptions are not evidence. Report on. You should go by what you heard and received. Any communications with the court during deliberations would be in writing. Cannot share notes, but you can look at them. Your own notes. Notes are not to be considered transcripts. Notes are only a stimulus for your memory. Asked to have portions of the transcript read back to you if you would like. Each side was given 1 hour and 15 minutes for the closing arguments. State asked for a 30-minute warning. So they started out with a picture of Ramos and the standards of policing. I put P next to that for paraphrase because that's a paraphrase. And in paraphrase, I forget the name of it. It's not Cobb. It's one other guy. So there were, I think it was 6 prosecutors total. Yeah, so there were 6 assistant prosecutors and assistant prosecutors. There were 4 people actually talking in the case, according to a reporter. That's where I got that information from. And when I came in and saw this, I saw 6 people and 2 people talking on closing arguments. So take that for what it's worth. Let's see. I trusted him with weapons and ammo. There was no reasonable basis for him to do what he did. You don't always get it right. But was it immediately necessary? And I'm paraphrasing here. I can't go word for word what was said. And it's totally possible the jury heard something completely different in their own mind, right? And other people that were there. And someone said, I am a student. I think was it Cobb? Is either Cobb or the other gentleman that said, I think it was Cobb actually. Cobb said, I am a student of the human condition. So there's an irony. There's another interaction with the police that Mike Ramos had that was a much more positive that day before this incident. I said that was a great irony. Policing is not inconsistent. He went over what should have been the defenses. Let's see, court charge not to consider failure to retreat, defense of self, third person, slide not advancing. So yeah, the slide wasn't. They were having some technical difficulties while Cobb and his associate district attorney was making arguments. But I got to say, Cobb, the special prosecutor in this case, is a really good prosecutor. He delivers arguments quite well. Even if they're bad arguments, he delivers them to just well, I gotta say. And yeah. Mentioned that the last relationship he had was with another officer that day. I guess that's the irony, right? They show it's the exhibit of the positions of the officers from above. It's like a computer generated. It's the exhibit. You went over reasonable belief. It is not a sense. It is not a well-meaning thing. It is same circumstances that another person would do given the same circumstances. Blah blah blah. Jury has the benefit of knowing what the officers did in the same circumstances, which they didn't shoot, and that's a good point. To be fair, he was the only officer that shot that day. It could mean that that officer either did not have reasonable, you know, did not act reasonably given the circumstances. Like it could mean that, definitely. And that's what it seems to allude to. It could also mean that Taylor had a unique perspective that no other officers had, given that exact circumstance. And that in his mind's eye, with his training and all that, he legitimately believed in that snippet of time with what he saw and what no other officer saw, that deadly force was apparent upon the other officers, and that he needed to protect those other officers. That's what the defense seems to allude to. So yeah, Cobb said, listen to your common sense. You know what to do. What you first thought when you saw that video. It's a good argument. This is your moral conviction. There are generally accepted police practices. He was never a threat to any person, Michael Ramos. Most dangerous place Michael Ramos could be is in this person's head. And he pointed to the defendant. That's pretty powerful, actually. Talking about remaining situationally aware. Trusted with a weapon. Unsupervised. That's what he said. It's paraphrased, but he did say, basically, I do remember the word unsupervised. So, the defense made an objection. The state is using a non-jury charge. For their argument. The judge overruled them, said this is closing argument. So he continued, Mr. Cobb, on the state side. He's training not to be on the optic until ready to shoot. And he talked about the direction of the car. Think about all this before you take that shot. I've wrote that in quotations. Actions of the other officers mentioned. The defendant made a statement to the Special Investigations Unit, which is not the admin portion of Internal Affairs, but is the criminal investigation portion of Austin Police Department. I think that's important because from what I understand, and my understanding could be incorrect, but there's an admin side of internal affairs of police officers, which will punish them in an admin capacity, whether they will be at that department or not. And then there is a criminal investigation portion that has different rules for what they, can they remain silent and all that stuff. So on the admin side, they, I think generally are not allowed to remain silent. They are required to cooperate. But that information cannot be turned over, at least here in Austin, Texas, in this department, cannot be turned over to the Special Investigations Unit unless it is something related to perjury. So take that for what you will. So he made a statement to the criminal investigation side of the internal affairs. And yeah, so it was a statement he prepared with his defense attorneys. It's a state exhibit. I obviously did not write it all down because it was a little lengthy. First two shots, not looking through the optic. This is a paraphrase of that statement. Third shot he looked through the optic, aimed at head. And apparently, according to Cobb, that was around 14 seconds. That time frame from beginning of the officers pulling up to, I think, the first 2 shots. After third shot, could not see subject through optics, stopped firing. And I think that was a excerpt from the statement, or at least a paraphrase of such. I can't wait till the transcripts come out because it's a lot of stuff. There's a lot moving very quickly to write it all down as quickly as you can. At least the most important aspects of it, from my perspective, which can be wrong. State Exhibit 91 was presented. Distance of vehicles. Second shot was the lethal shot, according to Dr. Hayes, a witness in the case, I think on the state side. I wasn't there for the entire on trial, unfortunately. I wish I was, but I'm a regular guy and I gotta pay my bills, so I had to work. And they also presented State Exhibit 88, 89, 90, and it's basically different slides of the first shot, second shot, and then third shot, final shot. They went over the direction of the entry, shot wound. Then they went over what Detective Hart and Kenku Harkins did. Those are both police officers. Collection of relevant video stills. It's an exhibit, so they took all the relevant stills of that moment in time. I wanted to ask, but I couldn't because I was in the gallery. What shot that was? Oh, shot number 3. Okay, so I wrote it down. Shot number 3. So it was. So shot number 3, they took all of the available video and photographic evidence and put it on one slide, and that's what that is at this exhibit. Got a 30-minute warning from the judge. Well, yeah, so we brought all the civilians we could bring. For some of these people, courtroom is the only place to get sent to prison. So, I believe that this place is a place where justice could be had. Let's see, am I missing anything up to this point? I'm sure I am missing something. This is not a transcript. This is not me looking at a transcript. This is my own notes as fast as I could write and, you know, take in what they're saying and write it down at the same time. It's a lot. So I think that's when Cobb wrapped up. Excuse me. For some reason, I'm thinking Cobb said... So I don't think this was Cobb. And I do apologize for being so confused about this because I think Cobb actually said something of that was the same thing. So, and that's what's throwing me off. So it wasn't Cobb. This was the other gentleman. And he says, "I will see you on the other side." That was his closing remark. I thought that was kind of weird, but maybe it worked. So O'Connell was up. Mr. Doug O'Connell on the defense side. And he wanted a warning in 25 minutes. Yeah. And so Doug started off with the burden of proof chart, as you might see in some courtrooms. It starts with, like, you know, least burden of proof all the way to the top, which is like a red rectangle that is beyond a reasonable doubt. Showed that up, and while he was doing that, Doug did seem a little animated. He did seem a little angry in this case. Yeah, he started out with this. This comes down to one thing and one thing only. Were his actions reasonable? That's a paraphrase. I think he might have said it in slightly different semantics, but paraphrase of what he said. He said it's a tragedy, but it's not murder. A Prius male holding gun up, smoking crack. That was the report given to. That was the information conveyed to dispatch and the officers. Holding a gun up. smoking crack, doing drugs, something of that effect. The officers self-assigned, they moved towards the threat. Have to assume he has a gun, Mr. Ramos. It's a high-risk traffic stop. And then he went to the witness officer slide. And I wrote in quotations that Doug said, if only he had complied. And Doug went on about how the DA's treated this officer hostile, very aggressively, and with great disdain. Whether that's true or not, that's for you to decide. That's what it seemed to have said in paraphrase to the jury. Christopher Taylor didn't vote on the training he received and the procedures. I understand if the, and this is paraphrasing, I understand if the laws are not correct or right, but I encourage you to call your officials if you don't like the training. But he didn't have a vote on that. That was his training. And to judge him on something that is not his training wouldn't be fair, and paraphrase, of course. He went over the jury charge, reasonable belief, ordinary and prudent person. I would do that too. Then, so he said, you know, if you were thinking to yourself, I would do that too, then you cannot find him guilty. And he's talking about how what the state has been going over is a distraction. He is presumed to be innocent beyond a reasonable doubt. Presumption of reasonableness. There's a presumption of reasonableness. You know, did he intentionally or knowingly shoot, stop the threat, asking you to follow the law? Could have. This court case could have been about something else entirely. It could have been a whole nother charge. Not murder. The DA picked murder. You know, it could have been assault with a deadly weapon, right? Because murder, I guess, gives the... No, this is layman thinking here. This is not what he said or what was said in court. But layman thinking here is, if it's murder, there was intentionality in it. There was malice, right? Some level of malice. You wanted to kill that person, right? That was murder. That would be murder. And it seems like he's alluding to, this should have been like assault with a deadly weapon charge, you know. Probably would, you know, but the state chose murder. He intended, the state is saying he intended to kill this man. He wanted to kill this man. Burden of proof, evidence, Dr. Hayes, expert, quote on slide. I misinterpreted the data. Wrote that down. I don't know what that means. I think that's what Dr. Hayes might have said. Chris did not have a lot of time or distance. And that's important. It looks a lot closer in real life. The woods were blocked. That was not about a reasonable exit. So apparently, when Mr. Ramos pulled out of his car, initially he went forward. Now this is in debate. This is in debate for sure, depending on what video you look at and how you interpret it. But it seems like the Prius moves forward before it turns right. But even if he did turn right, there's nothing there. There's like just woods, according to the defense side. It seems like there's no way. There's nothing to go to. It's just woods. There are no, or there's something, if there is something that's blocked, or like some concrete thing or something that's blocked. I think I need to do a part 2. It's getting